Indian news, always the best news in town. Just some and a essay Kosobio. A bar NPP NDC, a memo once and some dear any what China Indian news more and an hour 20. Yet here in some are a coso and nay and what Yamano Simimu. Now yet to me and Fabi and so near her be a suswa and the body one and so ever far. In Simbi a chabu are men person with the man of also cry. Young put here in Simimra the bar. Deɛ aka biara nso no yɛde bɛtoa wo so pɛ sɛ wode comment ɛbɛto aseɛ na ebiom koraa mpo no pɛ sɛ wobɛsubscribe to yɛn channel no na afoforɔ nso so anya bi ahwɛ anya bi atie na other news bi ɛfa ho biara no yɛtumi de ama wo. When it comes to politics and governance, whether NPP NDC deɛ a Nimdeɛ news ɛwɔ ɛberɛ de ma wo paa. Nsɛm bi ɛtwa gu ɛnnɛ yi ɛwɔ Ghana man mu wɔ Ibadan politics na nkurɔfoɔ pii na nso na ɛkyɛ wɔn adwene ɛwɔ nsɛm yi ɛho. Menim sɛ wo nso wɔ adwenkyerɛ yɛtie nsɛm yi mmara sisi a deɛ ba a yɛaka biara no yɛde ɛbɛtoa wo so ma remfi sɛ ɔbɛsubscribe wɔ sɛdeɛ mede kaka kyerɛw no yɛntie mmara sisi a na kyerɛ w'adwene nso ɛwɔ ho.
Chief Justice Godfred Torkonu. Well, she's been suspended, but a number of Ghanaians seem to be interested in the issue. They've raised issues about unconstitutionality. Otafo Member of Parliament, he's been to the Supreme Court, he's tried injuncting the process, but that was unsuccessful. A new twist to this is that her ladyship herself, she has filed a case at the Supreme Court, and she's been represented by former Attorney General Godfred Odame. We're in the offices of the former Attorney General to speak to him on this and other issues emerging out of the attempt to remove the Chief Justice. You're welcome to Channel 1 TV.
Thank you very much.
It's been 4 months after the NPP lost the election. A lot of the NPP folk we know said it was a difficult defeat, a moment for them. How was it for you?
Well, I think this is not the first time we have been in opposition. We were in power from 2001 to 2009, and we're in opposition. And some of us, we had our law practice. Our law practice thrived, and all. So for me, the only change is, of course, the office that I hold. But in terms of law practice, it's business as usual. Because the office of Attorney General, for me, was a professional office in a way, even though the Attorney General wears two hats, Minister of Justice, by virtue of which he sits in cabinet. The primary functions of the Attorney General essentially are law-related, to be the Minister of Law and ensure that there's efficient administration of justice in the country. So I enjoyed it, and I still enjoy law practice, just as I did before I went into government.
So the switch wasn't difficult. I mean, taking your books, coming back, going to court, and now being on the defense side rather than being on prosecution.
Oh, definitely not. I mean, as I've said before, we all knew it was not a permanent office. Yeah, we as Attorney General, yes, we're Attorney General, and it cannot be Attorney General for life. So, yes, the only difference is the kind of service that was rendered. That was public service, and now it is private law practice. And so I can charge you fees even for speaking to me. But of course, I will not.
Now, that means partners. It should be new, right? A lot of people knew you from your days at Akufo-Addo Prempeh Co. Is Damian Partners new, or has been there while you were still at Akufo-Addo Prempeh?
So, interestingly, Damian Partners has been incorporated since 2017.
Wow.
I was at Akufo-Addo Prempeh Co. Started from 3rd October 2020, 2003. And then by 2017, after 14 years of practice with the Akufo-Addo Co, I felt that it was time to move on and establish my own law firm. So indeed, in January 2017, I incorporated Damian Partners with a view to moving into private practice from a different chamber. That's my own chamber.
Oh, so this is not a post-2024 thought?
Definitely not. The documents of incorporation are there. I formed it in 2017, but consistent with my virtues, I decided to keep it on ice, essentially. I did not have the law firm activated because right after I incorporated, the president nominated me as Deputy Attorney General. So I said, well, I did not want a situation where there will be conflict of interest, whereby my law firm may be engaged in cases and people will say that I'm assigning cases from the office of Attorney General to my law firm and that kind of thing. So I just decided to just keep it on ice. There was no practice at all. So right after we lost power, right after we officially exited office, I revived the office. And so within no time, about a month or so, I took a month's rest. Thereafter, I obtained my solicitor's license, chamber registration license, and then the law firm started.
How has it been so far? I mean, running your own private practice?
Well, it's been interesting. It's been good. You have the freedom of choice in terms of selection of clients and all. Of course, I do a lot of pro bono work as well, as I used to do and all. And so, of course, we also have to keep body and soul together. So there's a lot of commercial practice as well.
Anybody who knows you would be fair to say that the modus operandi really has not changed that much. Because NPP in opposition, you will take a lot of constitutional cases to court. The Ejechum and the rest, you were involved in those cases. But is it fair to say that this is the biggest case as of now for Odame and partners?
I mean, as you yourself indicated, I've been familiar with these kinds of cases. I remember the very first prosecution of the MPP ex-government officials in 2009. The then former Foreign Minister, Godfred Odame, that trial was conducted by me successfully. So he was charged with 8 counts of willfully causing financial loss, breach of procurement law, and abuse of office of profit and all that. And I succeeded in acquitting him. Thereafter, I did quite a number of matters. I acted for various people, including the president himself, Nana Addo Dankwa Akufo-Addo. I was his lawyer in various matters, the action challenging whether he was a lawyer or not, by Justice Pega, as well as other matters. And if you are there, so I'm used to that. In terms of Odame and partners, yes, we have been handling the matter of the dismissal of public sector workers who were dismissed from the public service some time ago. And then we took on this challenge. Constitutional cases are really not new to me. And I believe that is why the lady Chief Justice, perhaps in recognition of my humble expertise in that regard, decided to call on me to assist. And of course, it's something that I've always been speaking about, independence of judiciary and all that. So I had no difficulty at all lending my assistance.
We'll come back to what people have been saying about your involvement and whether it is good for the case or not. But did this case find you or you found it? I mean, we know that the OTAF member of parliament, he went to the Supreme Court, even before the CJ engaging you. Did you have an idea of taking up the matter or he approached you?
No, so, yes, he approached me. I mean, Vincent Asafua, that he was really concerned about the happenings in the country, the attempt overt, as it was, to remove the Chief Justice from office, and that he found unconstitutional. And I looked at the provisions of the Constitution, and I examined the relevant best practice internationally, and I recognized that clearly what is happening in the country betrayed a litany of constitutional violations and all, and therefore it was appropriate that we took up the challenge, which we did, and which is still pending before the court. It's not over. It is only the injunction which has been dismissed. So before that sitting of case already, next week we'll be setting out the issues for intervention by the court, and then we'll have the court hear the matter on its merit.
Is it a matter that you seem to have taken an entitled and unentrained position to say that everything about the processes to remove the Chief Justice is unconstitutional? Because from the beginning, when the president says he's consulting the Council of State, that's when you started raising issues about unconstitutionality with the process till date to the formation of the committee, and even objecting to some members of the committee. It looked like every step of the way you want to find a problem.
I mean, it cannot be an entrenched position at all. The point is that we have a constitution, we have the letter of the Constitution, and we have the spirit of the Constitution, which essentially sets out the rationale behind the various provisions that we have there and how they ought to work out in a way as to achieve a proper functioning of the society. And it is also interesting to note that when I was in office as Attorney General, I actually started the process of enacting regulations to govern the operation of Article 146. It is something that is in the office of Attorney General the Director of Legislative Drafting will have it. The current Attorney General, I'm sure, if he's interested, will have it and will know. So,
what stalled it?
Because the process of enactment of legislation, whether subsidiary or primary, goes through a process. It has to go through stakeholder consultation. In the first place, we actually received a letter from the Judicial Council. Yeah, the then Chief Justice wrote asking us to commence the process of enacting regulations to govern Article 146 and all. We did a full draft. I have a copy that I can even share with you. Subsequently, we set it for stakeholder consultations, which is eliciting the views of various stakeholders, the Judicial Council, maybe the Ghana Bar Association, the General Legal Council, and all as to it. It is after that the legislation could be laid in Parliament. And we could not complete that, and then the elections came. So it is there to be continued.
Now, let's talk about the current case as we have it, the issue with which you are representing the suspended Chief Justice. A lot of people seem to find the views you're pushing in that rate interesting. The first one has to do with the demand for the hearings to be public. People say that it's an open and closed book. 1468 says all proceedings should be in camera.
So I think it's important to indicate that, number one, this is the very first time a Chief Justice has had to issue a writ in the courts of Ghana. Has never happened. And that's because the Supreme Court has always been the bulwark of the protection of the independence of the judiciary. And clearly, any time there's been an attempt to remove a Chief Justice in the history of the country, the Supreme Court has had to intervene. And that intervention is on account of the fact that there ought not to be any interference whatsoever by any person or authority in the administration of justice or in the independence of the judiciary. And so what is happening is quite interesting. I would say that whenever there has been an attempt to undermine our democracy, it has always begun with an attack on the judiciary. Like I cite the example of the First Republic. In 1963, there was the removal of 3 Supreme Court judges, in fact, the dismissal of 3 Supreme Court judges, including the Chief Justice, Sayako Kosa. Within a few years down the line, there was chaos, and then there was a coup d'etat, because it was thought that if the primary institution, which will be the bulwark for protection of rights in the country and for ensuring that whenever the executive wants to overreach its powers, it is brought in check, has been interfered with, then there's no hope at all for the society. In 1969, when there was a mass dismissal of public sector workers, they called Apollo 571 or so, the Salah Attorney General case and all, the Supreme Court ruled in favor of the dismissed workers, and essentially, and the Puja government was compelled to comply, but the then Prime Minister made a famous remarks that no government can compel employment of workers. A year thereafter, 1972, there was a coup d'etat. In 1979, 1980, there was an attempt to remove the Chief Justice. The Chief Justice was subjected to parliamentary vetting, even though the Constitution, the letter and spirit of the Constitution, the spirit in particular, because the Constitution was a little bit ambiguous in terms of the specific prescriptions as to whether a Chief Justice who held on from the military, the ex-military regime, should continue as Chief Justice. But the Supreme Court interpreted it to mean that clearly, yes, such a person was still a Chief Justice and should not be subjected to parliamentary vetting. The Chief Justice had been subjected to parliamentary vetting. He also, in compliance with it, even though he did so under protest, subjected himself to vetting and then was failed. And clearly, it means he was supposed to leave office. The Supreme Court intervened and said no. But that attempt to interfere with the judiciary was significant because a year later, there was another coup d'etat.
From the narration.
Yes. And then after 81, the gravest assault on the independence of the judiciary in Ghana was witnessed. 3 High Court judges were picked up in the middle of the night and brutally assassinated. They were murdered in cold blood, and has ruined the scar on the conscience of the nation. And I think that these developments are very worrying, and therefore when there's any attempt which clearly is unjustified to remove the Chief Justice, it ought to be brought in check. And we find a government which has come into office on account of a rhetoric showing an inclination to deal with the judiciary, that the judiciary is biased and they're going to clean it up, they're going to reset it, and they need a new Chief Justice, and the new Chief Justice will help the nation better and all that. And so they come to office with such rhetoric, and then they embark on systematic patterns of conduct to give effect to that which is abhorred by the Constitution. I'm saying that the rhetoric that they engage in, the kind of comments that were made by President Mahama, were clearly the kind of sentiments that the Constitution of the country abhorred. The Constitution clearly, explicitly, in Article 127, Clause 1 and 2, prohibits interference with the independence of the judiciary by Parliament, by the President, or by any person or authority at all. And so if a person comes to office as President and comes with a narrative that he's going to change the judiciary, he's going to deal with, we need a new Chief Justice and all, and such rhetoric is repeated by key members of his government. We've seen Asidin Ketia make such comments, Mr. Fagbande clearly said the Chief Justice has to go and all that. Now you see that, no doubt, we ought to be concerned about what is going on. So, and they know that they cannot achieve that except